Hello, it's Bernard Nomberg with Nomberg Law Firm. I want to take a few minutes and talk with you guys about a certain defense in workers' compensation claims, and that's the willful misconduct defense, which can be an absolute bar in certain situations from receiving any workers' compensation benefits, such as compensation or even at times medical treatment as well. There are certain types of willful misconduct that are defined in the Workers' Compensation Act, and I want to go over just a couple of those with you because they do come up from time to time. One is the purpose or intent or design to actually hurt another person. That's coworkers who have a agenda or an issue between themselves that may not have anything to do or related to the work environment. It could be just a personality quirk or problem they have outside of work. A second one could be the intentional removal of a machine safety guard that or safety device that came from the manufacturer. Oftentimes you'll see where they've taken off the guard that prevents someone from interacting or being injured by different types of either knives or saws that are in mills, for example. Another, and this is probably the most common that we've dealt with, is the intoxication defense. And that's when someone is either under the influence of alcohol or an illegal substance, and that has led to either their own injury in the workplace or someone else's injury. And there are some issues that I'll discuss in just a second that come with that. And then lastly, the fourth one that we have that are listed in the law books is the willful and intentional violation of a written safety rule that has been issued by the employer but is blatantly disregarded by the employee, and that leads either to the employee's injury or the injury of a co-employee. One example of that could be taking off or not wearing seatbelts or not wearing certain types of safety equipment or entering into certain areas of the place of employment where you're warned, not just verbally but in written form, and that leads to injury. Almost 100% of the time when someone gets hurt on the job and they go to the hospital or a clinic or to a doctor's office, they're going to be drug tested either immediately upon arrival or within 24 hours. And depending on what the drug screen comes back will determine if there's going to be an issue with the defense of intoxication or being under the influence. If in fact if the intoxication or being under the influence caused or contributed to the workplace injury and accident, that could ultimately be used as a defense. And what we see in workers' compensation cases is that it's usually the injured worker who is intoxicated or tests positive in some way. The insurance carrier for the comp insurance company will typically pay for the medical care as provided for under the Comp Act, but will not pay any compensation weekly benefits unless or until we're able to prove that the intoxication or the drug screen that came back positive was not a contributing factor to the actual accident itself. I'll give you a couple of examples that we've dealt with at the office over time. Had a fellow who was working in downtown Birmingham. They were the construction company he was working for was rebuilding or repurposing a large warehouse. He was in an area where he was permitted to be. He was changing his shoes from his work shoes to his, I'll call them civilian shoes. He was on his way to leave to go check out. He was wearing his protective gear, including his hat, helmet, and he was changing his shoes when a large bit of ductwork from high above, 30, 40 feet above him, fell out of the rafters. It had come loose, was not properly secured. It fell on top of his head and his neck and crushed 3 vertebrae in his neck, and he was immediately rushed to the hospital. He tested positive for some type of illegal substances, but ultimately, or initially, they did pay for his medical care but wouldn't pay him any comp benefits. But we were able to prove that even though he tested positive for a banned substance, that had nothing to do with how he got hurt. He happened to be test positive, but it was not his fault or any thing that he contributed to his injuries. So ultimately, we were able to recover compensation benefits for him as well as for medical care. On the other hand, we've reviewed and turned down many, many cases where people have tested positive, but their test of intoxication or positive test results did in fact lead to the accident or the injuries, driving under the influence, those kind of things. So there's the real defense there. These issues come up all the time in our practice. If you have questions or concerns about this type of fact scenario or this type of defense, please give us a call at the Nomberg Law Firm, 205-930-6900. We're in downtown Birmingham. Nomberglaw.com is our website. We also can be found on social media, Twitter, and Facebook.